Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Professor of Law at the University of Kentucky College of Law. My guest is George Conk, Senior Fellow and Adjunct Professor at the Lewis Stein Center for Law and Ethics at the Fordham University School of Law. We will discuss his article, People's Electric, Engaged Legal Education at Rutgers-Newark Law School in the 1960s and 1970s, which was published in the Fordham Urban Law Journal, among other things. So welcome to the show, George.
Thank you. My pleasure.
So I'm really excited to talk to you about this paper because I didn't know this story that you told about Rutgers Law School. And I'd really like you to sort of just start maybe by kind of explaining what was so unique and special about Rutgers-Newark Law School, especially in the period that you describe.
Great. The opening of the article kind of tells the story of me and that place, which was that I had just returned from 2 years in the Peace Corps in India. And I just started graduate school. I was studying with the radical historian Howard Zinn at Boston University. And the cause célèbre of the moment was the prosecution of leaders of the anti-war movement and of one of the two founders of the Black Panther Party, Bobby Seale. And so that trial was called the Chicago 8. And the posters for soliciting support for that case said, join the conspiracy. And so they were being tried at that moment in the United States Court of Appeals for the Seventh Circuit in Chicago. And there was a rally, and I was a young anti-war movement activist, fresh from 2 years in actually a small town just north of Bombay. And here I was, I'd missed Woodstock and was a student of a guy who was prominent in the anti-war movement. And so I was a natural, and I went to a rally sponsored by the National Lawyers Guild at Harvard Law School, and it was a packed room. And the speakers included two of the defense lawyers for these leaders of the anti-war movement. And just to give you a sense of the moment, it was a trial that was very contentious, and the judge was very harsh and ultimately held the defense lawyers in contempt. And the most notorious moment was that the leader of the Black Panthers, Bobby Seale, had been bound and gagged and strapped to his chair in the courtroom. So that was the kind of atmosphere of what was going on. And the stemwinder speech was by a Rutgers law professor who had been a prominent lawyer in the Southern Civil Rights Movement, Arthur Kenoy. And Arthur Kenoy's three great triumphs were the cases of Powell versus McCormick. McCormick was the Speaker of the House of Representatives, and they had voted to bar the Black Harlem Congressman Powell from taking his seat in Congress because he had brought discredit on the institution when he was found civilly liable for slandering a woman who he called a bag lady for the numbers racket. And so Congressman Powell, who was one of the most prominent Black leaders, was successfully allowed to take his seat as a result of Kenoy's representation. And the case is Powell versus McCormick, and it was a breach in the wall of the justiciability political question doctrine. His other big win was a case that arose in the South when a prosecution was enjoined on the grounds that it had been initiated in bad faith. And his third was United States versus United States District Court, in which he successfully obtained a writ of mandamus. This while I was in law school. And I actually had a very, very small hand in that case. So in U.S. versus U.S. District Courts, the writ of mandamus blocked a search warrant that had been issued on the grounds that it was a foreign intelligence based warrant, and yet there was no foreign intelligence involved in the case. The defendant was a kind of fringe political figure. So here was Kenoy, and he was leading the legal backup team for the trial of the Chicago 8. And he was a stem-winding speaker, and he stood there and said, the legal backup work that is being done at Rutgers Law School in Newark, and there are law students in the library till midnight tonight and every night doing the work necessary to fight off this attack. And so he gave these kinds of speeches around the country, and we all came. So he recruited this class of young activists, and we got to Rutgers Law School and found that Rutgers Law School was a very special place. For one thing, it was a school that had as a mandatory course for first-year students legal representation of the poor, and its minority student program, which had been initiated by Willard Heckel, who had just stepped down as dean, had as a goal to recruit first 20 African-American students, and then in the next year to recruit 30, and 30 in the following year. And so when I started Rutgers Law School, 30 of the 150 members of the entering class were African-American or Latino students.
For listeners who who don't know what law school education was really like firsthand during that period, I wonder if you could contrast your experience at Rutgers Law School at that point in time with what law school was like at other schools.
Well, first of all, there weren't Black students in any significant numbers unless you went to a historically Black college and university. And there was no such thing as a law school in the North that had 20% Black students. The other thing was that the presence of women students was really trivial just about every place except Rutgers-Newark, where these the ranks of women were greatly bolstered by the newly resurgent movement that referred to itself as the Women's Liberation Movement. And they were attracted, many of them, by the fact that one of the first courses on women in the law was being taught by a civil procedure professor named Ruth Bader Ginsburg. And so there was the place, this influx of principally African-American students, anti-war activists, and young women energized by the women's liberation movement. And that made the place unique. I should add one other thing, which is that it was a state university and the tuition was $500. And my choices about where to go to law school were Boston University and Boston College, and I think I was waitlisted at Berkeley. But $500 for law school. BU was $2,500. So that also made it possible for this successful recruitment, particularly of minority students. So there was no place else like it.
Well, could you talk a little bit more about some of the other faculty members? Because it sounds like at that period of time in particular, the law school had a lot of really interesting, important, and frankly, radical people on the faculty.
Well, the first, of course, was Arthur Kenoy, the one who had won Dombrowski versus Pfister, the injunction against a bad faith prosecution. And he was the leader of the appellate proceeding in the Chicago 7 case. And so the first thing that happened was there were 20,000 pages of transcript, and dozens of us volunteered, and we were given 1 or 2 volumes each to summarize the facts and help him with the brief. So he was the first. He was the Pied Piper. But others included Frank Askin, who would later become general counsel of the ACLU nationally, and who was the longtime director of the Constitutional Litigation Clinic. He was particularly involved with police surveillance issues. He had filed a case called Anderson versus Sills, trying to stop the surveillance of anti-war demonstrators by police throughout the state of New Jersey. He was an important leader. William Bender was a staff attorney at the Constitutional Litigation Clinic. The second case that I ever worked on, the first was the Chicago 7 case. I remember Kenoy said to me, write an ex parte Milligan point for me. I don't know what our ex parte Milligan was, but I, took some facts and read the case and put some words together. But Bender I worked for, and in the summer after my first year, and the case he was working on was Jeanette Rankin Brigade versus Chief of the Capitol Police. And that was a group of middle-class women who had been barred from parading on the steps of the United States Capitol. And they filed a lawsuit, and it was joined by people like Congressman Ron Dellums of the one of the founders of the Congressional Black Caucus, and Bella Abzug, the liberal congresswoman from Greenwich Village. And so that was a challenge to the constitutionality of the statute that barred parades on the Capitol grounds. Alfred Blumrosen was the first general counsel of the Equal Employment Opportunity Commission. He and his wife, who was an impressive lawyer herself, had been involved in some of the most important civil rights litigation in the state of New Jersey, challenging, among other things, racial discrimination by the real estate developer, the suburban real estate developer, Arthur Levitt, who built 3 Levittowns, one in Long Island, New York, one in New Jersey, and one in Pennsylvania. Blumrosen started something called the Administrative Process Project, of which I was a student. And that was a 10-credit clinic. Anna Mae Shepherd had been a lawyer in private practice and a leader in the local legal aid society, and she was the third female faculty member, and she started the Urban Legal Clinic, which was basically a legal services office run out of the law school, in which her co-director was Richard Chusett, who went on to become a law professor at Georgetown. Paul Trachtenberg was interested in education, and he was a driving force behind the litigation in New Jersey, which went on for 40 years to try to accomplish more equitable funding of schools in the state. And he founded, I'm blanking on the name of the Education Law Center, which is based in Newark. I guess that brings us to Ruth Ginsburg. And so Ruth Ginsburg was a specialist in civil procedure. Her scholarly work had been on Swedish civil procedure. And the women all clustered around her. We called her Ruth. And she, in civil procedure, she was my civil procedure teacher, laid out her strategy, which she expressly based on Thurgood Marshall and the NAACP Legal Defense Fund strategy. And her objective was to establish the principle that gender-based distinctions in the law should be treated as a suspect classification. So she laid out that strategy, and the litigation that she was just beginning, which is the first litigation of her life, in civil procedure in my second semester of law school. The next year, she had the first seminar in Women and the Law, and there was no such thing as Women and the Law. There's a very good book called Equal. The name of the author escapes me at the moment, but it's cited in my People's Electric article, and he tells the story of that era, the women's rights litigation. So Ruth Ginsburg's first seminar on women in the law at Rutgers, the first thing she assigned was Simone de Beauvoir's The Second Sex. There was no literature of women in the law, but she set about solving that problem. And she brought in a brilliant woman named Nadine Taub, and with a group of women students, one of whom later married Professor Chusett, they founded the Women's Rights Law Reporter, and that was the first. That was the first women's rights law reporter or law review in the country, as far as I know. And then there was the minority student program, and Lennox Hines was actually a student there. He became the director of National Conference of Black Lawyers, and that was led by Alfred Slocum, who was a black professor who had graduated first in his class from Rutgers-Newark, and then gotten the Ivy League dip, gone to Yale for a year and gotten an LLM, and came back as a professor. And so he was the faculty leader, along with Charles Jones, another black professor who taught criminal law, of the minority student program. And so that was what the place was like.
So, George, I wonder if you could talk a little bit about this wonderful name, People's Electric. Where did that come from? What did it mean? And why did the name seem to mean so much to people who went to school there?
There was a band in California called People's Gas and Electric. It partly came from there. Using the word "peoples" was a very popular, kind of radical thing at the time, and electric was a term. There was the famous recording studio, Electric Ladyland, and electric had this kind of psychedelic uh, uh, connotation. So it was just a coinage by one of us. I don't know who, and so we called it People's Electric Law School. It was a place where people lit up in more way than one.
Well, so to what extent do you think that the sort of Rutgers, Newark, People's Electric model of the 1960s and 1970s has informed legal education today? And how do you think, we might incorporate more of that into what we're doing in legal education?
The first thing we'd really want to do is restore the principle of making public education affordable. That was much of what made Rutgers possible, so that you could go to Rutgers Law School aspiring to engage in public service and come out of law school not burdened by debt. And so that is a big obstacle in today. Rutgers-Newark, which is now merged with Rutgers-Camden, which was somewhat more traditional in its approach to legal education, is still a center. They have not lost the spirit. The dean who recently stepped down, Ronald Chen, who's Chinese American, was first in his class at Rutgers, eventually in Newark, eventually became the dean, came out of the minority student program, has been a brilliant lawyer for the ACLU, a leader in public service in New Jersey, and uh, and a brilliant guy. I'm on 3 committees with him: the advisory committee on professional ethics of the New Jersey Supreme Court, the editorial board of the New Jersey Law Journal, and the amicus committee of the New Jersey State Bar Association. But unlike the usual course to becoming a dean, I think that the only law review article he's ever written is the one that he wrote for the Rutgers Law Review when he was a student. So that model has persisted at Rutgers-Newark, which is that clinical education and engagement in impact litigation is as valued as is scholarship. And there are some great scholars there. James Gray Pope has done work that I think is absolutely brilliant on Reconstruction. His essays on Crookshank are, I think, transformative, really. So there's lots of good scholarship there. It's not that scholarship is discounted; it's that it's driven by the desire to have an impact on how the law develops.
Yeah, it's true. I mean, it seems to me that even scholars at Rutgers are also people with impact. I know my law school friend Tajania Henderson has been there for a while, and she's done a lot of really cool stuff.
Yes, she's great. If you want to find a law school that's of the same spirit today, Northeastern University Law School is, I think, probably the closest to Rutgers Newark then and now in spirit. And it's not coincidental that the former dean there is Roger Abrams, who had been dean of Rutgers-Newark. But when you look at scholarship of people like Wendy Parmet on public health, Richard Daynard on his tobacco litigation, product liability project. That's a school that has valued impact litigation in a way very similar to the transformative litigation, especially on things like open housing, the line of cases in New Jersey that was initiated at Rutgers-Newark, the equitable school funding litigation. So I think that equitable school funding is an area where there's room in every state to have an impact, and I think that that would be a good place for law schools that are looking to have a public impact, especially in the present moment, to look to develop both scholarship and clinical work.
Well, so I wonder, do you think that the legal academy and sort of the kind of legal profession in general undervalue clinical education and the kind of engaged legal pedagogy that you're describing?
Yes. Yeah, of course. Of course they do. The accreditation authorities don't require that clinical professors be given tenure like everybody else. So, I don't think you need to go beyond that to be able to answer the question. Yes, it doesn't have the same respect in the academy. The academy has moved toward theory rather than doctrine. I think that's another thing that has that reflects a reduction in the value placed on having an impact on the law. The days when we turned to law professor treatises, whether on evidence or damages or the like, for guidance as practitioners, have also waned. So the engagement, the degree of engagement and interaction between law schools and the practice has also reduced.
Well, so George, I was wondering if you could spend some time talking about how you took your experiences at Rutgers-Newark and sort of put them into practice in your own career. In particular, I know that you had an interesting experience representing Stephen Jay Gould. I wonder if you could talk about that briefly.
Well, when I practiced law for myself. I was self-employed from 1979 through 2006. And I started off trying to develop a plaintiff's personal injury practice. I worked at a law firm that did that kind of work and occupational disease work. And I had contacts in the trade union movement and factories. And so I was involved with issues of occupational safety and health. And I represented dozens and dozens of workers who had occupational lung disease. And also probably the most lucrative part of my practice was product liability claims resulting principally from hand injuries in heavy industry. So my personal financial interests concurred with my kind of ideological loyalties. And so I developed some expertise in product liability law, and particularly was interested in occupational lung disease. And so I started, I didn't have many of those clients myself that were exposed to asbestos, but I got work writing for other lawyers, doing some appellate work. And a moment came when the New Jersey Supreme Court issued an order asking for additional briefs for a case to be re-argued, and the case was called Landrigan versus Celotex, and its companion case in what they called increased risk cases. So I wrote a brief about how to make use of epidemiological evidence in order to prove causation, and in order to do that, I deepened my study of the work of the great epidemiologists who had brought to public attention the dangers of asbestos. But then, when courts were asking, how should we handle novel scientific opinions? That was the way they framed it in New Jersey, and also in a federal case called Christofferson. And what use should we make of epidemiological evidence? I learned of that order, and I was editing a newsletter for the state bar, and I tried to find somebody to write about it. And then I said to myself, you know what? The case isn't over. Get into the case. So I wrote a friend of the court brief for the Trial Lawyers Association. And the arguments that I developed was that you can't just do these things by the numbers. You have to assess the evidence in a kind of all things considered way. And so my objective was to defeat an argument that you had to show a doubled risk of disease in an epidemiological study in order to prevail on causation. But the subtext of that was that I started reading about epidemiology, and Austin Bradford Hill, the great British epidemiologist. And the next, and we won this case in New Jersey, Landrigan versus Celotex, which presaged what became the Daubert case. And so when the Daubert case, Daubert versus Merrill Dow Pharmaceuticals, which was a pharmaceutical product liability case, came to the Supreme Court, the conservative attack was based on the idea that expert opinion testimony should not be admissible unless it represented the consensus opinion in a field. And so I'd long been a subscriber to Natural History magazine, because I really enjoyed the monthly columns by Stephen Jay Gould, who wrote a lot about the nature of scientific knowledge. And I remembered on my bookshelf Thomas Kuhn's The Structure of Scientific Revolutions. And that said, it's not just consensus, right? The scientific progress advances through contention, rather like the law does. And so I wrote an outline for the Trial Lawyers Association that used Kuhn's argument structure with the idea that Stephen Jay Gould would sign on to this argument. And so the Ned Miltenberg, who was the vice counsel of the Trial Lawyers Association, went to Kuhn, and Kuhn said, I don't get involved in that kind of stuff. Go talk to Gould. And so then he went to Gould and said, Kuhn said to talk to you. And once Stephen Jay Gould signed on, then he was a superstar, and then everybody else wanted to be associated with it. And so it became the brief of philosophers and historians of science. So we formed one pole of the argument, and we said, look, it's like Galileo. Sometimes the dissenting position is the right position. Uh, Consensus is not what judges should be looking for. What they should be looking for is whether something is soundly reasoned. And basically, we won that argument in the Supreme Court, in the opinion of Justice Blackmun. And it took a while for the courts to sort it out, but I think it worked out okay. The basic standard now is that expert witnesses have to bring the same rigor to and methods to their courtroom opinions that they do to their ordinary professional work.
So, in addition, you've done recent work on Chinese law. I wonder if you could talk a little bit, just briefly, about the work that you've done and why you found that interesting, and sort of how that might have informed your thinking about American law.
Okay, so the way that happened is I represented the Hemophilia Association of New Jersey, which was supporting product liability claims by hemophiliacs who'd gotten AIDS and hepatitis C. And I used those facts to develop a critique of the proposed very restrictive rule on drug and medical device product liability enunciated by the ALI in the Products Liability Restatement. And so I wrote that up, and as a single practitioner, as a small firm practitioner, and circulated it to a bunch of law reviews. I was teaching part-time at Seton Hall by the time, and sent it out in beginning of July, and got a bunch of offers. And one of those calls was from the Yale Law Journal, and was it available, and was I willing to accept their offer? And so I said yes, and it came out in March 2000. And 6 months later, I got a message from a PhD candidate at Peking University who said, this is a very interesting article, and as our law develops, this could be very helpful to Chinese legislators. Could I translate it? So I thought, I wanted to have an impact on the law. That's why I did all this. So now am I really going to have a chance to change the law in China? So there was a rebuttal, and I had a follow-on piece, and they were all translated and published in the same journal. And so I hired an editor to assist with the translation. And so when that was all done, I wanted to go meet these people. And having the experience of 2 years in India, I knew that I did not want to go to a foreign country like that and be illiterate. I wanted to be able to communicate. So I started studying Chinese, and then I did the natural thing, which is, I met people and who were at the leading universities, and they gave me a copy of the then draft civil code, and I brought it to a Chinese law expert, Professor Whitmore Gray at Fordham, and said, Whit, you translated the basic principles, the general principles of civil law from Chinese into English. Do you want to translate this? And he said, no, you do it. And he said, here, and he handed me his worksheets on, including his glossary from his translation of the 1986 law. This was 2003 or 2004. And so I just set about doing it, and I'd liked translation work from when I studied Greek in college. In high school, rather. Actually, high school and college. But one of the most fun things in my life was translating the Odyssey from Attic Greek and there was something about the magic of things emerging from this strange tongue that always intrigued me. And so that's what happened with Chinese. So I was the first person to translate the draft Chinese tort code, and I published it in 2007. And I just last week posted a translation of the Chinese tort section of the new comprehensive civil code that was passed on May 28th. So that's how that came to be.
Amazing. Well, George, I wonder if, in closing, I know you're an avid sailor, and in particular, a huge fan of wooden boats. I wonder if you could talk a little bit about sailing and wooden boats and what they mean to you.
It's The Craft of Sail is one of my favorite books about sailing. And I think it's the physicality of it, of responding to wind. It's wood, water, and light is actually the magic of wooden boats. And the interaction of wind, waves, and sun, I've loved since I was a child. And my father sailed, and I sailed as a boy. And we have a house on the coast of Maine in a famous boat building town. There's nothing more absorbing to me than responding to the changes in wind and water and the quiet of sailing.
Well, George, thank you so much for coming on the show. It was a real pleasure talking to you, hearing about Newark Rutgers and all of the amazing things you've done. And I look forward to seeing what comes next.
Okay, great. Well, let me just add one more thing, which is that I'm not the only one who pursued that. My classmate Wade Henderson was the leader of the Lawyers Committee for Civil Rights Under Law for many years. My classmate Donald Lieberman is the now longtime leader of the ACLU in New York. Carlin Meyer, a classmate, was a longtime law professor at New York Law School. Lennox Hines led the National Conference of Black Lawyers. And I always need to remember to mention Dale Jones, my classmate and fellow trial lawyer at the Public Defenders. And Dale led the Capital Defense Unit for many, many years, for 20 years at the Public Defender's Office in New Jersey, which ended with the repeal of the death penalty and no one executed. So there are a lot of people who have pursued, engaged the legal education from that era, and we've had an impact on the law.
Well, God willing, Back to the Future, I think it's a model we could really use going forward.
So thank you very much. I really appreciate the opportunity, Brian. And I want to commend you for your fascinating work about the inventor of a plow, the slave inventor of a plow. It's not only your article, which is fascinating, but some of the work that it spawned are.
Yeah, Kara Swanson's article I think is so great.
Yeah, I just read Kara Swanson's article, and I found it very moving, and particularly in this week and this month when we're so in heightened awareness of of our history and the impact of slavery and the struggle for recognition of the contributions, particularly of African Americans, to our country and our culture. So thank you for your work. I think it's really beautiful work.
Well, thank you, George. I really appreciate it. Thank you for coming to the show. This was really fun, and it was really a pleasure to highlight how cool Rutgers-Newark is. And I hope everyone really gives them credit for all the amazing stuff that law school has done over the years.
Thank you very much. My pleasure.
Would you have freedom from wage slavery, then join in the grand industrial band? Would you from misery and hunger be free, then come do your share like a man? There is power in the band of working men when they stand hand in hand. That's a power that must rule in every land. One industrial union grand. Would you have mansions of gold in the sky and live in a shack away in the back? Would you have wings up in heaven to fly and starve here with rags on your back? There is power in the band of working men when they stand hand in hand. That's a power that must rule in every land. One industrial union grand. If you've had enough of the blood of the land, then join in the grand industrial band. If for a change you would have eggs and ham, then come do your share like a man. There is power in the band of working men when they stand hand in hand. That's a power that must rule in every land. One industrial union grand. If you like sluggers to beat off your head, then don't organize, all unions despise. If you want nothing before you are dead, shake hands with your boss and look wise. There is power in the band of working men when they stand hand in hand. That's a power that must rule in every land. One industrial union grand. Come all ye workers from every land, come join in the grand industrial band. Then we our share of this earth shall demand. Come on, do your share like a man. For there is power in the band of working men when they stand hand in hand. That's a power that must rule in every land. One industrial union grand. One industrial union.